Hi everybody, this is attorney Arkady Frekhtman, and today we are going to go through some recent verdicts and settlements in New York. Now these are all types of personal injury cases, and they're just organized by what's happening now, the most recent. So one of the most recent that I see here actually came down in the Northern District of New York, which is a federal court. Now federal courts tend to be a little bit more conservative. And let's see if that proved to be true in this case. It was decided in May of 2024, and it went to trial, and there was a jury verdict. And the case stemmed from an incident on March 3rd of 2019, when the plaintiff, who was a young 18-year-old college student, was involved in a skiing accident. So what happened was she was skiing on a beginner trail at a mountain in northern New York when she fell, slid across the trail, and then struck a snow gun. What happened was she claimed that the snow gun was on the ski trail, yet should not have been there, and that there were no markings to warn the skiers about the snow gun. And then her attorney further argued that the defendants failed to place guards or pads on the snow gun to protect skiers, and argued that the defendants' actions rose to the level of gross negligence. And the resort argued that the snow gun was not on the ski trail, and they had a biomechanical engineering expert to give the opinion that commercially available pads would not have prevented these injuries, that even if they put pads around the snow gun, it would not have prevented the injuries. That's the defense's expert. And the resort further claimed that the plaintiffs accepted the inherent risk of downhill skiing, and that the ski area complied with the safety rules and the state statutes. Now the injury here, it was 5 pelvic fractures, and there was a fracture of the sacral alar, acetabellum, and a few other fractures. And there was a pelvic ring displacement, a thigh hematoma, and a torn hip labrum. So pretty serious injuries. The young plaintiff consulted and treated with multiple orthopedic specialists and claimed that the injuries caused a post-traumatic fatty necrosis, a permanent deformity, painful popping, and symphysis disruption. The plaintiff's orthopedic surgery expert gave the opinion that she will likely develop hip arthritis and require a total hip replacement. And the expert further argued that she'll be unable to deliver a baby naturally because of this injury, and that she will require a cesarean section if she ever conceives a child. She sought recovery of damages for her past pain and suffering, her future pain and suffering, and also sought punitive damages. And so the result was actually a defense verdict. The jury concluded that the plaintiff did not assume the risk of her injuries. So that's good, right? Because when you ski, they could find that you're assuming the risk. It's the risk of skiing. It's not. So they actually found that she did not assume the risk of her injuries, but they found that the defendants were not negligent, that the defendants didn't do anything wrong. Unfortunately, this one was a 0 result. But the demand was actually $750,000. And there was an offer of only $30,000. So they didn't really lose too much. The trial took 5 days, and the jury deliberated for about 2 hours, and the jury vote was 8-0. All the jurors agreed, 8-0. There were 5 male and 3 female jurors. But again, this is federal court, which tends to be more conservative. Now the next case is in Queens County, also in May of this year. And what happened here was that on October 31st, Halloween of 2017, the plaintiff, who was a home attendant in her 50s, slipped on fruit and a wet substance at a supermarket located on Jamaica Avenue in Queens. And so she claimed injuries to her lower back and both knees, and she sued the owner, I guess the owner of the food corp, as well as an individual who owned, maintained, or controlled these premises. The injury was that she claimed a medial meniscus tear to both knees, a herniated lumbar disc at the L4, L5 level, and a bulging lumbar disc at the L5, S1 level, and she had chiropractic care, physical therapy, as well as imaging studies. She treated with numerous doctors, including an orthopedist, a neurologist, and a pain management doctor. She received approximately 3 nerve blocks to her lumbar spine. She was recommended for knee surgeries, but she did not undergo the procedures, and her treatment ended around June of 2019. It started right around the date of the incident, which was like end of October 2017. She missed approximately 1 month of work before returning to her job, but she could only return on a part-time basis. And in the 6 months after the fall, she was unable to walk upstairs, mop her home, wear high heels, lift heavy items, or stand for an extended period of time. And she claimed there was an inquest, because what happened was one of the defendants failed to answer, so there was a default judgment. And during the inquest, she claimed that she was still in pain and her sister still has to mop for her. So she sought recovery of $28,000 in past medical expenses, $150,000 in damages for the past pain and suffering, and $300,000 for future pain and suffering. And following the inquest, the judge determined the damages. And the judge determined that the damages here were, it was $278,187.48. So less than the plaintiff asked for, but still a significant amount. And now the plaintiff will try to obtain those damages from either the defendant or try to enforce through collections and then see. Oftentimes when you try to do that, what happens is they then wake up and they make a motion to vacate the default, but then they have insurance and then they answer, and then you can try to settle for that same judgment or close to it. We actually had that happen just recently. And the way it broke down was it was $28,187.48 for past medical costs, $150,000 for future pain and suffering, and $100,000 for past pain and suffering, so altogether the $278,000. The trial took 2 days, and like we said, the judge decided this one because it was an inquest. The next case is out of Westchester County, which is upstate New York, and what happened here was it was a lawsuit where it was alleged that the hospital staff failed to recognize and treat signs of DVT, which is deep vein thrombosis. So this was actually a medical malpractice case. And the facts here, what happened was on October 17th, 2018, the plaintiff, who was 48 years old and was an accountant, was a patient at Westchester Medical Center in Valhalla. And the day before, he was hit by a car while cycling, and he was brought to this hospital and diagnosed with a traumatic brain injury. He recovered from the brain injury. However, he developed a deep vein thrombosis in his lower left leg. And on November 18th, about a month later, he was still in the hospital. He suffered a pulmonary embolism, and he ultimately went into cardiac arrest and died approximately 1 month later. And so his widow, acting individually and as the administrator of the estate, sued the hospital and various related entities. And basically they argued that the hospital staff departed from good and accepted medical practice, standard of care, and that this departure led to the death of her husband. And the plaintiffs also sued 2 doctors, but those doctors, one of them was discontinued and the other one was dismissed by summary judgment. So the only remaining defendant at the time of trial was the medical center. And so the plaintiff counsel argued that the hospital staff should have inserted an inferior vena cava filter on either October 17th or 18th, and that this filter would have prevented the pulmonary embolism by trapping blood clots before they reached the heart or lungs. And they further argued that from November 9th to November 18th, the hospital staff missed signs of impending DVT and pulmonary embolism, and that the husband had repeated signs of agitation on November 18th, and that he was coughing up blood for 3 weeks. The plaintiff's counsel also argued that the family had been complaining about him sweating and kicking his left leg, and these were all signs of a deep vein thrombosis and or pulmonary embolism. And they further disputed whether the hospital staff properly utilized sequential compression devices between November 11th and November 18th, because the hospital's nurse practitioner submitted an errata sheet where she changed her testimony that she gave in her deposition regarding the reason why she canceled her order for these devices, these sequential compression devices. She ordered them, but then canceled it, and then the reason was changed in her deposition. Because when you finish your deposition, you're given an errata sheet, and if there's any mistake, you can fix it. But she changed the substantial, not just, it's a material change, like the reason why you canceled these devices that may have saved someone's life. So, and the defense argued that the plaintiff suffered a sudden, unpreventable pulmonary embolism that he did not show any warning signs of, and they claimed that he was coughing up blood. This symptom was caused by the tracheal tube placement rather than a blood clot. And the defense also theorized that the fatal clot may have come from the upper extremities, right? Not from the legs, but from the arms. But the plaintiff's attorney during cross-examination showed that it was a less than 10% chance that the clot came from the upper extremities. So you see, like medical malpractice cases, they get very, very technical and very detailed on the medical records as well as, medical probabilities. And so the injury here, it was the pulmonary embolism, the cardiac arrest. Doctors recovered a pulse after 28 minutes, but he was declared brain dead, and he was transferred to another hospital for hospice care on December 21st, and he died on December 23rd, and he was survived by his wife and 2 minor children, 7 and 10. And both children testified that their father used to cook, clean, pick them up from school. He also taught his daughter how to play piano. The daughter testified that she struggles with her Spanish homework and that she would likely be fluent in Spanish if her father, a native Spanish speaker, was still alive. She added that she is sad her father will never see her wedding day. And meanwhile, the son testified that the father will never get to coach the son's soccer team. So the wife sought recovery of damages for her past and future loss of services, and the estate sought recovery of past and future lost earnings and damages for the children's past and future loss of parental care and guidance. Here, what happened was, the result was that the jury found that the hospital departed from accepted standards of care by failing to appropriately utilize the sequential compression device and by failing to appropriately monitor the decedent for signs of a DVT, a deep vein thrombosis, as well as a pulmonary embolism. And the jury concluded that these departures were a substantial factor in causing his death. And there was a hung jury on the question of whether the hospital departed from accepted standards of care by not placing the inferior vena cava filter. So you see, like in medical malpractice, you get specific jury instructions as to specific departure. So one of them, there was a hung jury they couldn't decide on, but the other one about the devices, they said, yeah, that's a mistake, especially since one of the defense staff said, we changed the reason why she canceled the order. And so ultimately the jury awarded the plaintiffs $23.3 million. So it was a big verdict. And there was also like another one I did, another video where there was over $100 million verdict in Westchester for medical malpractice, I think against the same hospital. So if you're in Westchester, maybe try to go to another hospital. That's two verdicts, 100, and that one was like over 100 million. This one is 20 million. Interesting. So the way it broke down was past lost services was 1.5 million. Future loss of services for 25 years was 7.5 million. So the total amount was 9 million for the wife. And then for the estate, it was 300,000 for past lost earnings, 4 million for future lost earnings, 4 million for past loss of parental care and guidance, 6 million for future loss of parental care and guidance for 25 years. And the total there was 14.3. And the judge, I know the judge, actually we had, when we did our Westchester trial, I believe in October of last year, we had the same judge help us. He was very helpful, but he was the judge who presided over this case. The demand actually in the case before the verdict, the demand was 3.5 million and the offer was 300,000. The trial took 9 days and the jury deliberated for 2 days. So they were out a long time, and it was 4-2 on this inferior vena cava filter question. So that's why it was a hung jury, because it has to be either 6-0 or 5-1. So it was 4-2 on that issue, but it was 5-1 on the other liability causation questions and 6-0 on damages. And it was 4 men and 2 women on the jury. Okay, so I hope this has been helpful. Let us know what questions you have. Please like and subscribe to our channel. And remember, we are here for you. Our goal is helping serious injury victims and families.